that judge has no respect for his own judicial oath. I don't think he read the law. That Circuit Court 9 judge, I have no respect for him. For a judge to say that he's remanding Abronye into BNI custody until the case is finally determined. Such a judge can never have my respect. I pray that he summons me for contempt.
Enti enye nim say NDC for ebedi aban yi de MPP ne members omuhunto omu efi say wa abekwa akotro ade ato wo ho e wo social media handle so na wantro ni EOCO You so AI eye bibi wa anye ni yi a ye ba bechewo wa betena wo social media so ye video akeka nsem bi a wankeka ni yi ye baba bechewo na echi ni so e 2 stars o ida say more invitation na wa sori kodu pani a lock you anase wo da dem Rambo style ni aba befaw ni do kwa ube condition there say tie na say the whole Ghana and no NMPP for say enough is enough because aboba babedru abronye so ama abronye me no ka say there or remand for 2 weeks no mubuofu no my press conference eye Afenyo Markin na oye minority leader ono no kasaye na kasaye na yebufo so ene wadwa ama President Mahama wagene share Chief Justice Bafuboni ono so agene share and Supreme Court judges almost wajo mo share and na High Court judges almost wajo mo die and Circuit Court judges ajo mo die and afi media na nkasa almost wajo mo share be ba be bo video no Mr. we no wa subscribe no wa share ama onuaba why
we have documented case after case since this administration assumed office on 7 January 2025, the list grows longer by the week. Let me mention just a few. David Esando, MPP Aguna West constituency organizer, arrested by approximately 10 armed national security operatives. His crime? Posting an image of President Mahama with the caption, "Doomsaw is back." But isn't Doomsaw back? 10 armed officers for a Facebook post about electricity outages afflicting millions of Ghanaians. Then Mr. Abubakar Yakubu, MPP Sunyani East Communications Officer, popularly known as Baba Amando, arraigned before an Accra Circuit Court, remanded, charged with offensive conduct, false publication and circulation of statements likely to incite fear and panic. The same judge, Circuit Court 9, the Agenda Court, the NDC Court. And let me repeat it. That NDC judge, he must be ashamed of himself. Mr. Alfred Abebio Kumi, known as Adente Kumi, was arrested by operatives of the National Investigation Bureau in a dramatic dawn raid on his home. His wife suffered a miscarriage as a direct consequence of that raid. His crime? Submitting a petition to the president concerning the conduct of committee members sitting on the Chief Justice removal proceedings and making comments in media interviews and on social media about the same matter. He was formally charged with publication of false news under the same statutory provision being used against Abronye today. And there's a case of Reverend Intim Fojo, a member of Parliament for Asin South, and a ranking member of Defense and Interior Committee of Parliament. This is a sitting member of Parliament, a duly elected representative of the people. Again, BNI operatives attempted a raid on his residence after he raised concerns about 2 aircraft that visited Ghana and alleged possible links to drug dealings and money laundering. It took his colleagues in the minority caucus to physically resist attempted arrests. Dr. Baumia, our flag bearer, himself had to visit him to reassure him that a member of parliament should require reassurance that he remains free after raising matters of national security concern in the discharge of his public duty is a statement of the most alarming kind about where this country is headed. And now Abronye, remanded into BNI custody for criticizing a judge. There are no isolated incidents. They are selected examples from a deeply troubling and growing list. That judge has no respect for his own judicial oath. I don't think he read the law. That judge has no respect for his own judicial oath. I don't think he read the law. That circuit court 9 judge, I have no respect for him. For a judge to say that he's remanding Abronye into BNI custody until the case is finally determined, such a judge can never have my respect. I pray that he summons me for contempt. I will continue to disrespect him until he upholds the law. He's gone beyond his judicial function. And it is not his first. It's as if he has been selected purposely to achieve this. He doesn't talk law. I don't know whether he ever passed his law exam. It's a shame. It's a shame on the judiciary. And my Lord Bafuboni must pay attention to this. For whatever it is, it's about his legacy. I'm told by December, he will be 70 and he will be gone. Is that the legacy he wants to leave after Tokonu was booted out of office? And all manner of accusation leveled against Tokonu. Is that the judiciary? The judiciary, they said they were going to reset. Is that the reset? Where a judge will say he is remanding an accused, because if he allows him to go home, if he grants him bail, he is likely to talk again. So he should remain in custody. In fact, at first, his pronouncement was that Abronyo should go to Nsawam until the case is finally determined. He's already prejudiced the outcome of the case. And this man says he's a judge. I should respect him. No way. And some fool say, our flag bearer, Dr. Mahama, has rightly described as an unholy collaboration, this conduct, between the executive, state investigative agencies, and some element within the judiciary aimed at silencing the MPP. He is right. More than right. The pattern is undeniable. This is state-sponsored political persecution, and it must stop. Now, a word to the judiciary. You are to be the guardian of liberty, not instrument of power. I now address you, my respected learned members of the bench, and I've used respected advisedly. And I do so with gravity. This moment demands. The 1992 Constitution, my lords, vests judicial power in your hands as the judiciary and charges you with a solemn mandate to be independent guardians of the rights and liberties of the Ghanaian people. Article 1253 declares that judicial power of Ghana shall be vested in the judiciary. Article 127 fortifies that with the guarantee of independence. These are not ceremonial provisions. They are the constitutional foundation upon which every citizen's liberty ultimately rests. It is with the deepest concern that this party NPP observe how the court have conducted itself in this matter. A bail application grounded on orthodox legal principle was dismissed on a basis that no serious reading of Article 14 and 19 of the Constitution can sustain. A citizen has been remanded into the custody of an intelligence service on misdemeanor charges. What has happened to the old principle of law? That should all men find a man's hand in a tail, proving under his lordship, Bafuboni's leadership, you are guilty before you are pronounced guilty. You are guilty before full trial. So my Lord Bafuboni, and Bredudua wire judge, Anyamia drum, Omutu, Tokonu Yaya, Ubedi Chief Justice, Sadia Wena Wudija Ghana, Enumquasio, my Lord. Biweni, Nasha de Echo Form, Echo So Formo. Said Judge, Otumika say, Obin Corremand. So said, Yebedina se maybe. Supreme Court judges, Court of Appeal judges, High Court judges. Monsorin Kasa. Na de court no egum na mwanimu ase. Ye de mo a mo begum hu fi no. Ye mpampa mo ye be kasa, mo pe amon remand yen. Mo pe mo nka contempt na mo fa yen ko prison. Ye be ko yensro. Ye na nanu mo o mo de party be bo ase no. They went through similar ordeal. It never broke them. At every turn, the scales have tilted not toward the protection of liberty, but toward its curtailment. A court that allows itself to become a tool for silencing political opponents has ceased to be a guardian of liberty. It has become a participant in its destruction. I am aware of the climate in which our judiciary is operating. I am aware that this is a government that has shown it is capable of defiling our constitution to haul a sitting Chief Justice out of office. I am also aware that some members of the judiciary may be afraid. They look at what was done to Chief Justice Tokonu and ask themselves whether standing up for the constitution is worth the personal costs. I can understand that fear. But there are some also who are still wearing partisan colors and are refusing to look at the law, and they are bent on taking backdoor instruction from the executive to do their bidding. Those must change their attitude and respect the human rights of every Ghanaian, irrespective of their party color. The people of Ghana look to the courts as the last line of defense when the executive overreaches. The trust is earned by the fearless and impartial application of constitutional principles, especially when the person before the court is politically convenient to those in power. A judge who surrenders to fear and becomes a timorous soul, too intimidated to defend the constitution and the rights it protects, is no longer a judge. He has become an instrument of the powerful. The court that reserves its constitutional courage for safe and inconsequential cases and abandons it precisely when it matters most has dishonored the robe. I call upon the High Court to take urgent cognizance of the circumstances of Mr. Abronye's detention, including the reported absence of a signed and certified remand order, and do the needful. Now, Ghana has been here before. The culture of silence does not announce itself with a decree. It does not arrive at your door with a proclamation. It arrives as likely like this, incrementally and surgically. A communicator of a party is arrested. An organizer is picked up there. A regional chairman is remanded into security remand. The message spreads quietly through every rank of the opposition. This is what dissent costs. The Mahama administration has calculated that intimidating MPP communicators and silencing its regional leadership will allow it to govern without accountability and shield its mounting incompetence from scrutiny. That calculation is profoundly wrong and it will fail. It will not work. The MPP will not be guarded, not by arrests, not by bail denial, not by BNI detention, not by any instrument of fear this government deploys. The freedom to speak, to criticize power, and to hold government accountable is not a privilege granted by any administration. It is a constitutional birthright, and it cannot be revoked by any government on earth. Abronya's voice may be temporarily caged. Let the government understand clearly. 1,000 voices will rise in its place. And that is not a threat from the party, but rather it is the unbreakable promise of Ghanaian democracy we are reiterating. Now our demands. We make the following demands, and they are non-negotiable. First, Mr. Kwame Bafo Abronye might be relieved from BNI custody immediately. His detention is constitutionally indefensible and must end today. Second, our legal team will mount full constitutional challenge to this prosecution, including challenge to the application of sections 207 and 208 of Act 29 against political speech where civil liberties are available and adequate. Third, Parliament's Constitutional, Legal and Parliamentary Affairs Committee shall, upon assumption of Parliament, be made through an application to summon the Inspector General of Police, the Director General of BNI to publicly account for every decision taken in this matter. The Chief Justice is not also above the law. Parliament will use every law under its command to summon the Chief Justice. They must all be answerable. And let the majority know this. In the effort by the minority in ensuring this is done, they should not try to stampede it. It is good for democracy, and we call on the majority to support it, because tomorrow they may be in opposition and they may need this very law to protect them. I repeat, for our friends in the majority in Parliament, I call for their cooperation, even as the minority in summons the Chief Justice and the Director General BNI to appear before Parliament.